today. I'm actually very pleased. I know we've been talking about UNDRIP, and we've adopted it. I believe we adopted it in June, or was it Toronto? I'm not quite sure now. We followed the lead of PPWC, were very progressive on this, and I believe now the provincial government has adopted UNDRIP. So that's very progressive. That's great. So it gives me great pleasure to introduce Sheryl Lightfoot today as our keynote speaker on UNDRIP. Sheryl, podium's yours.
Thanks so much. Is this on? Mm-hmm. Okay, perfect. First of all, I want to open this morning by acknowledging and thanking the Musqueam, Squamish, and Tsleil-Waututh people on whose traditional, ancestral, and unceded territory we meet when we meet in downtown Vancouver. And so I always like to open by acknowledging their shared sovereignty and history on this land that we now call Vancouver. And I want to thank you very much for inviting me today. It's a pleasure to take this opportunity to talk about the UN Declaration on the Rights of Indigenous People, which, as you can see by my all too many titles, is my specialty at the University of British Columbia here in Vancouver. And academics love to load us up with titles, but essentially, let me parse it down. I have faculty appointments both in political science and in Indigenous studies at UBC, and then I have a Canada Research Chair of Global Indigenous Rights and Politics, which specializes in Indigenous human rights, the UN Declaration, and the implementation of it. And I just got off a flight last night from Europe. I was up in Scandinavia working with a couple universities there that work with the Sami people in the north, the Arctic Circle of Scandinavia. And so we are working towards a research network of universities spreading from Sydney, Australia, through New Zealand, across Canada, and into the Scandinavian Arctic to focus on practical measures to implement the declaration. So it's a live issue and policy area and of great interest to many folks and in many sectors in all of those countries. So it's my pleasure to be here today and talk about this, both a little bit from my academic perspective, but also very much from a policy and advocacy perspective, and talk about what implementing means and how you can support it, since I do understand you have adopted the declaration. So I want to spend my time this morning telling you a little bit more about it. I am Anishinaabe from the Lake Superior Band of Ojibwe, which is a group of people that have lived around circumnavigates Lake Superior. So we've been living on both sides of that lake and all around that lake for about 10,000 years since the last ice age. And so the border is a brand new construction to us. It's only about 200 years old. And I actually came from barely the southern side. So I was born on a peninsula. My reserve is a peninsula in northern Michigan that juts out into the lake, stretching across into Ontario, just across from Thunder Bay. I've been at UBC for about 10 years now and in this position, and I was recruited to come to Vancouver and UBC specifically to do this work on the Declaration. So it, again, is my privilege to talk about that today. So to start with, this is the book that I published a couple years ago in 2016 on Indigenous human rights, and it's titled Global Indigenous Politics, A Subtle Revolution. And it includes a history of the UN Declaration, as well as a couple chapters of analysis on state responses to implementation, or what we also call compliance with it. So what I want to cover in my time this morning is several things. First of all, I want to discuss what is special and significant about the UN Declaration on the Rights of Indigenous Peoples. And then I want to take a closer look at global patterns of implementation. So who's doing what around the world in terms of where we're at with implementation? And then take a bit closer look at the current status of implementation in Canada, which is a complex and fast-moving, deteriorating, actually, story. So we'll go over some of that, which I haven't checked the news this morning, so it may have changed. And then finally, since your organization has already endorsed the declaration, I want to talk about some practical pathways of implementation and provide some suggestions on how you can support implementation in your work. And just to give you a broad overview, I argue in my book that the UN Declaration on the Rights of Indigenous Peoples is a remedial document, and it is intended to rectify what has been the widespread denial of of human rights to Indigenous peoples, both in national and global contexts. Okay, so I want to put forward two main arguments related to Indigenous human rights. And the first is that the UN Declaration on the Rights of Indigenous Peoples, or UNDRIP as it is unaffectionately known for short, always run your acronyms. This was one of the worst discoveries in this entire advocacy, was in several decades of drafting and negotiating this, no one ever ran the acronym. And it was only after it passed that everyone realized that it was UNDRIP. And so those who've been involved in the declaration for many decades just have a hard time saying UNDRIP because it sounds so poor. But it was a lesson in acronyms that now we always take a good look at. So the UN Declaration was actually a significant global achievement because it represents a very overlooked and underappreciated transformational moment in global politics. For the global Indigenous rights movement that had been active for decades, by the act of simply seeking international recognition of Indigenous peoples' human rights, by definition sought a fundamental set of changes in the United Nations, in the human rights system, and in the wider international system. And some of these changes are very small, but some are much larger and what I call subtly revolutionary. For the Indigenous rights body enshrined in the Declaration does not actually add new rights for Indigenous peoples, but it does, in the course of recognizing and accommodating Indigenous peoples' human rights, inherently shifts and challenges and changes some fundamentals of the system itself. The second argument is related to the first, and it's that because of the transformative nature of Indigenous rights, the real potential of it lies in how it will be implemented. In other words, the potential of this document lies in its potential. And the real potential of that is of implementation involves significant changes, which cannot strictly be compartmentalized for Indigenous peoples separate from other peoples. It involves changes in all existing systems and requires ultimately that we all think deeper and broader and larger about these changes. And in the book, I find that the UN Declaration and Indigenous human rights represent 4 sets of fundamental changes, not only to the rights of Indigenous peoples, but also to wider global politics. The first of these is that the UN Declaration was the first time in the history of human rights that a broad set of collective rights or group rights was accepted within the human rights consensus. Now, from its very earliest beginnings, grassroots beginnings in the 1970s, the Indigenous rights movement had asserted that a strictly individual rights focus and framing of human rights was and is insufficient to accommodate Indigenous peoples' human rights. For Indigenous peoples also need protections not only as individuals against harm and discrimination, but they also need protections as groups, especially in the area of cultural rights and land rights, and of course, political self-determination. Now, the United Kingdom and the United States, along with a handful of other countries like Australia, New Zealand, and Japan, all express longstanding concerns about incompatibility between group rights and individual rights. And Indigenous activists have reported that during the Cold War years, the United States routinely opposed any international instrument that included any collective rights or group rights out of fear that collective rights represented part of the communist agenda. So when the UN Declaration, as a broad statement in support of collective rights on principle, passed the UN by an overwhelming majority of 143 yes votes in the General Assembly, and was voted on by the United Kingdom, and then later endorsed by the United States, this was an important transitional moment in global politics that has largely gone unrecognized. And the U.S. endorsement of the Declaration later on in 2010 even included a very specific statement in support of group rights of Indigenous peoples. And that's the first time in U.S. history that they have ever supported any collective human rights document. And that represents a fundamental and overlooked shift in longstanding U.S. position against collective human rights or rights of groups. Secondly, the UN Declaration, at least morally and politically, corrects the discriminatory legal exclusions of Indigenous peoples from a wider global decolonization project. And again, from its earliest grassroots beginnings, the international Indigenous rights movement sought to correct two important highly discriminatory legal doctrines that have served as often the legal foundation of the settler states we call Canada, United States, Australia, and New Zealand. The first is the doctrine of discovery, and the second is the saltwater or blue water thesis exclusion of decolonization. Now, the doctrine of discovery actually comes out of the 15th century, papal bulls, and it was a series of papal bulls that justified European discovery, European claims, and exertions of full sovereignty over all non-European lands and peoples that they could discover. Now, the saltwater thesis is a very unknown working policy from the decolonization era of the 60s, 70s, and into the 80s. Now, in 1960, the UN officially outlawed colonial rule with its declaration on the granting of independence to colonial countries and peoples. And while this 1960 declaration proclaimed that all peoples have the right of self-determination, it neglected to define peoples. And it also offered no guidance on how to determine who was eligible for decolonization and self-determination. And a conflict immediately rose on the global level between those who were advocating what was called the Belgian thesis, which argued that all peoples, including those colonized within states, were entitled to the right of self-determination, while those who were supporting the alternative, called the saltwater or blue water thesis, argued that only colonial territories located over salt water or overseas were eligible for decolonization. Well, the saltwater thesis found a strange number of supporters, a strange coalition at the time. And remember, this was the height of the Cold War. So the strange coalition was both the settler colonial states of the Western Hemisphere, joined by Australia and New Zealand, and the Communist Socialist Bloc, which at the time, those two did not agree on much, but they agreed on this, which was that the Belgian thesis was a direct attack on both the multi-ethnic Soviet Union and on settler colonial states. So with those two forces in coalition, the saltwater thesis prevailed during decolonization. And it thus defined peoples eligible for decolonization and self-determination exclusively as those living overseas. And it became a legal doctrine fully excluding Indigenous peoples from the right of decolonization and also giving them a second-class right of self-determination compared to other peoples. So the UN Declaration and the Indigenous rights discourse that has come out of it, have delegitimized both of these principles in international law and technically corrected them, although the question of how exactly to do this and how this will be accomplished remains an item of ongoing negotiation both on the global level and within domestic individual contexts. So the third change, and this is where in many ways the rubber hits the road. The international Indigenous rights movement has sought and achieved through the UN Declaration to provide a guiding framework for what Indigenous state relationships should look like. Now, Article 3 of the Declaration states that Indigenous peoples have the right of self-determination equal to all other peoples. Now, at the same time, it also contains Article 46, which offers protection for existing state sovereignty and territorial integrity. And just as a side note, this 46 was an article that the Indigenous advocates had no role in drafting or including, but it was added at the end by nation states as protections for their sovereignty, fearing that Indigenous groups, particularly across Africa and Asia, could take the declaration as a right of secession. So that it made it very clear that this was not the case. So given that the decolonization project of overseas colonies is now largely completed, the question that we're facing on the global level and in each country is, well, then what does self-determination mean? If it doesn't mean the establishment of an independent nation state, what does it mean to acknowledge and to respect Indigenous peoples' self-determination as a fundamental human right? Now, according to the text of the UN Declaration, Indigenous peoples' self-determination means that they have, quote, the right to freely determine their political status and freely pursue their economic, social, and cultural development. And there are multiple possibilities just in the text that include self-government, autonomy, and various types of political engagement with the state. And virtually all the Indigenous activists that I interviewed over the course of nearly a decade all expressed that they have the desire for some sort of independent or autonomous structure within the state, but only a few, primarily in what I would call extremely remote regions, expressed a desire for independent statehood per se. As one individual told me quite nicely and succinctly, the state is actually a European colonial structure, and so we don't base our claims on it. What we seek is our role as nations, as peoples. We seek freedom and the space to live and govern ourselves as we see fit. That's self-determination. Statehood could provide it, I suppose, he said, but so can many other ways of thinking and doing things. Now, the Declaration itself doesn't provide us with any sort of prescriptive solution for what self-determination can mean in practice. And in fact, it's the opposite. It doesn't want to give us a universal prescriptive solution. Rather, it intends to provide space for the negotiation of a multitude of political arrangements, again, with stated options ranging from more or less full autonomy to self-government to participation within the state. And we have to presume that many other options could come to exist in the future as we imagine different possibilities. And so the evolving conversations in many of our countries about free, prior, and informed consent, which comes out of the fundamental right of self-determination, are also necessarily a part of this conversation. And the wider implication that follows is that self-determination as a human rights principle can and will mean something other than statehood. But again, what that means is constantly evolving on the global level. And Indigenous rights and the UN Declaration are in many ways leading that global conversation. Now, fourthly, and these are probably some of the most overlooked areas of the story on the Declaration, is that the advocates that worked together on the Indigenous rights movement over the course of almost 4 decades, which is almost 40 years that they worked on this one single project, from the 1970s until 2007, demonstrated that politics can be done in very different ways, and that the usual patterns of global power politics can be shifted and changed, and they have presented us some alternative pathways to how to conduct politics. Now, this movement, while transnational and with plenty of lawyers, is still largely a grassroots movement, an activist movement. And it is a deeply anti-colonial movement in both nature and in practice. But it consistently and in multiple ways has creatively challenged structures and institutions. And I want to highlight and provide a few examples of some of the major elements of the approach that the global Indigenous movement has taken across 4 decades. First of all, they conduct their own business through consensus decision-making. And the search for unifying Indigenous positions through a consensus model first appeared at conferences way back in the 1970s, beginning in 74 and 77. And the practice continues. And in the numerous caucus meetings that I've observed over the years, consensus has always been the primary objective and always the process focus. Now, occasionally, because the Indigenous caucus is constrained by time and resources as much as any other political decision-making body in any context, occasionally a vote is required to make a decision. Although, to the caucus, this is viewed as a highly undesirable last resort and a failure of sorts, because it means consensus didn't succeed. Secondly, there's a strong principle of broad and open participation, and always has been, including elders, youth, community leaders, and many, many, many women. And this broad and open participation model has always been a core objective of the movement and continues to be. And strong attention is paid to balance geographic inclusion among delegates, but also achieving a mix of community-based people, tribal governments, political organizations has always been a goal. Elders and youth are always included and often play a central role in meetings. Women's leadership has always been central, and gender balance is normally present, but without much deliberate discussion. It just is a natural fact, and women's and men's voices have been largely equally represented. Now, the cultural and spiritual groundedness has been a battle zone. Indigenous representatives began this struggle as early as 1977 in their first meeting in Geneva by asserting that they needed to have Indigenous culture and spirituality in official conference proceedings. And multiple Indigenous participants at the earliest Geneva conferences told me in interviews about the crucial importance of these cultural expressions in achieving global solidarity. And at both the earliest 1977 and 81 Geneva meetings, Indigenous participants absolutely insisted on opening and closing their meetings with Indigenous prayers and ceremonies in full opposition to all UN standing rules and procedures. And it's a practice that they fiercely clung to for over the years, and a tradition that's continued to this day, but has now become quite ordinary, routine, and accepted in Indigenous meetings at the United Nations. And then finally, in terms of practicing diplomacy, the Indigenous rights movement has always, from its grassroots origins, tried to stay grounded and connected to those roots and its community base of support. At the first 1974 treaty conference, elders, traditional leaders, and the American Indian movement activists deliberately shifted a bit away from the direct action protest model and more into an international diplomacy model called the International Indian Treaty Council. And then on the Canadian side of the 49th parallel, the leadership of George Manuel from this region was also rooted in activism. And a result of these two grassroots origins, the Global Indigenous Caucus is made up of numerous activists, which translates often into some strong personalities and individuals deeply committed to their cause. And so, at critical moments, the movement does not hesitate to utilize collective action techniques to challenge the UN system in order to provide fair and just access or accommodations. And over the past 3 decades, the caucus have engaged in a various strategic set of protests, walkouts, and even a hunger strike at one point in order to draw whatever attention was needed to UN structures or practices that were creating an unjust or discriminatory situation. Now, this is a chart taken from my book, which I'm not going to spend a great deal of time talking about, but it shows where Indigenous rights as global change have been, but also where the biggest challenges are. Now, prior to the passage of the Declaration in 2007, the international human rights law and it deliberately excluded the two elements that are critical to Indigenous peoples. As I mentioned earlier, it did not previously include collective rights or group rights to maintain such things as culture, language, religion, identity, or establish educational systems in their own languages in the face of assimilation pressures. Now, these rights that I call the soft rights are indicated in the box with the rounded corners. And generally, these are quite easy for nation states to accept and for civil society to accept. But also, Indigenous peoples' self-determination and the collective right to maintain their lands were, again, specifically excluded by a couple of those legal doctrines. Now, these are the hard rights that states tend to resist most fiercely, which is in the bottom corner where the explosion lies. And we see this moving into the contemporary period. Now, I separate rights out into the hard and soft categories in order to draw out state responses to them, because the hard rights strike at some of the fundamentals of states: land, territory, sovereignty, and political self-determination. And because Indigenous groups are presenting and pushing for change in these concepts, I term them hard, both to indicate the difficulty in negotiation, but also to talk about the perceived threats that they can play to the state system. And soft rights, like language, culture, education, are collective extensions of existing human rights. And while some recognition of these rights does involve some change to thinking about inclusion of collective rights, the changes required by states and the United Nations to secure these rights are not as fundamental as the changes brought forward by the hard rights, and so most states can accept them. Now let's talk about implementation. Implementation requires change, both on the international level and on the domestic level, on a state by state by state by state by state basis. And individual nation states are now expected to enact and implement legal changes, constitutional changes, legislative and policy reforms that can accommodate and respect such things as land rights, free, prior, and informed consent, in some cases redress, as well as the variety of self-government, autonomy, and other plural sovereignty arrangements, as we call them. Now, what I see as an academic is that the UN Declaration could represent a very early articulation of an entirely new international system. Instead of hierarchical top-down principles of domination, extraction, and exploitation, and colonial control, Indigenous rights, which have been largely articulated by Indigenous peoples themselves and negotiated over many decades, could potentially be on the cutting edge of something radically new. The principles here instead are mutual respect, sustainability, reciprocal relationships, and the ongoing negotiation of political questions. But the current picture of state implementation or compliance with Indigenous human rights is complex and, at least in the human rights world, a bit unusual. But what I've found is that with Indigenous rights, we actually have 5 possible outcomes. So we have both compliance and non-compliant situations, but we also have a whole array of what I've called under-compliance, partial compliance, and then a new concept that I call over-compliance. So in order to get to these, I looked at each country's Indigenous rights commitments, or what it promises it's going to do, and then compare it with their actual constitutional, legal, and policy behavior, or what they are actually doing, and then assign each country a ranking according to that analysis. Now, what we've got globally is 10 countries, or about 17%, that are completely non-compliant. In other words, they promise nothing, they deliver nothing. We have about 42, or 73%, that are under-compliant or partially compliant, meaning they promise a lot and they don't deliver on those promises. We have 2 countries at the time, or about 3%, whose promises and activity are actually in alignment, and that's a global number of 2. At the time, that was Norway and Denmark's situation in Greenland. And then we have 4 countries, or 7%, that demonstrate overcompliance, which means they tend to deliver quite well, but their promises are very, very low, which is a strange and unusual situation. This slide shows where the countries currently are at in terms of their compliance. And if you look, it doesn't look like there's much of an organizing framework here. They're all over the map. But the patterns, while it doesn't look like there's anything discernible, if we look region by region, we do start to see some things. So of the 5 circumpolar countries of the Arctic, we have quite a mix of compliance, partial compliance, and non-compliance. And again, the only more or less compliant countries in the world, and I was extremely generous with this ranking, are Norway and Denmark, with Greenland. Latin America, generally speaking, has high aspirations, but a serious implementation gap. All 15 countries in the region have high, sometimes extremely high levels of commitment in legislative and constitutional terms, but their actual policy behavior ranges from weak at worst to moderate at best. And so as a result, the region shows a very low rate of implementation, with every single country either under-compliant or partially compliant. Now, across Africa and Asia, we have a mixed picture, but it's also generally quite low. And some countries have high levels of commitment, but they also tend to not recognize that the peoples in their borders are indigenous. And so they interpret indigenous rights as being something that impacts other countries overseas. And then we have our 4 countries, the United States, Australia, New Zealand, and Canada, that are over-compliant, meaning they tend to deliver quite well, but they promise almost nothing, which is a strange and unusual situation. So an over-compliant country is one that takes constitutional, legal, and policy actions to recognize rights, but go way beyond its obligations or its other commitments. It's important to note that when I say overcompliance, I always put it in quotes, and it doesn't imply that the states involved are completely complying with, nevertheless exceeding international indigenous rights standards. They aren't. But it's only that these states are performing above the level that we would expect to see based on their very low commitments. So one of the greatest challenges confronting indigenous movements and indigenous advocates is to push for advances in these countries where we have a certain amount of defensiveness and active resistance to indigenous human rights, sometimes directly, sometimes legally, and then occasionally with force. So let's come closer to home and take a look at where Canada is currently standing. So in June 2015, Canada's Truth and Reconciliation Commission, or TRC, announced the release of its summary report. And this report included 94 calls to action. These 94 calls, which were intended to form the blueprint for reconciliation into the future, calls upon all layers of government, federal, provincial, territorial, and municipal, to make fundamental changes in their policies and programs in order to repair the harm done by the century-long residential school policy. And while the calls to action are generally directed at governments, there are parallel implications for civil society that resonate quite clearly. And central to these 94 calls to action is a call to fully adopt and implement the UN Declaration on the Rights of Indigenous Peoples as the framework for reconciliation in Canada. And it includes a call for a national action plan for implementation. In total, 12 of the 94 calls to action directly reference the UN Declaration. Now, the UN Declaration became a key issue during the 2015 federal election, which was launched in midsummer only a few weeks after the June TRC announcement. And within about 2 weeks of the TRC announcement, Liberal Party leader Justin Trudeau addressed the Assembly of First Nations in Montreal. He noted an urgent need for a renewed relationship between the federal government and Indigenous peoples in Canada, one built on trust, recognition, and respect for rights, and a commitment that the status quo must end. And Trudeau then also specifically mentioned the Liberal Party's response to the TRC would start with implementation of the UN Declaration, and the full Liberal Party platform, released very shortly thereafter, included that same language. And fueled by anger over the Harper government's policies on Indigenous peoples that had actually sparked the Idle No More movement in 2012, Indigenous peoples had their best showing at the ballot box in 2015 than they had in all the history of Canada. And in fact, in a few ridings, helped Justin Trudeau's Liberal Party win that election. And the newly elected Prime Minister crafted a cabinet that included 2 Indigenous members. And the mandate letters to ministers included directives to implement the recommendations of the TRC, including full adoption and implementation of the Declaration. And he stated in those letters that no relationship is more important to me and to Canada than the one with Indigenous peoples. Following up on that, in May 2016, both Justice Minister Jody Wilson-Raybould, then Justice Minister Jody Wilson-Raybould, and Aboriginal Affairs Minister Carolyn Bennett went to New York to address the UN Permanent Forum on Indigenous issues. And Wilson-Raybould spoke at the opening ceremony with a special statement on Canada's new position on the Declaration, on the Indian Act, on reconciliation, and on free, prior, and informed consent. And in this statement, she indicated the need for Canada to reform the ways it conducts business and the central role that the UN Declaration would play in that reordering and that renewal. And the very next day, Aboriginal Affairs Minister Carolyn Bennett addressed the very first day of the Permanent Forum. And she stated that her purpose in speaking that day was to address Canada's position on the Declaration. And she was there to announce that Canada would, after voting against it in 2007, now be a full supporter of the Declaration and without qualifications. Following loud applause and a standing ovation, she said, "We intend nothing less than to adopt and implement the Declaration." And then Bennett continued with an explanation of the new government's position. And she said, "By adopting and implementing the Declaration, we are breathing life into Section 35 of the Constitution and recognizing it as a full box of rights for Indigenous peoples." And she said that the constitutional obligations already fulfill the principles of the Declaration, including the important but controversial principle of free, prior, and informed consent, or FPIC. In the meantime, NDP Member of Parliament Romeo Saginash had tabled Bill C-262, the UN Declaration on the Rights of Indigenous Peoples Act, a bill that, if passed, would ensure that the laws of Canada align with and respect the Declaration. Now, this bill would not, like we see in Latin America, create a high level of legal commitment and leave an implementation gap. Rather, it takes a number of concrete steps to bring Canada into compliance. So it does several things. It sets out the key principles that must guide implementation. It provides clear public affirmation that the standards set out in the UN Declaration have direct application in Canadian law. It would require a review of federal legislation to ensure consistency with the minimum standards set out in the UN Declaration. It would require the federal government to work with Indigenous peoples to co-develop a national action plan for implementation. And it would require an annual reporting to Parliament on progress made toward implementation. It also, and this is a key piece, provides some assurance that once there is a change in government, and we know that change will come eventually, the commitments and the processes to implement the Declaration will already be enshrined in law, and they cannot easily be rescinded. In February 2017, the Prime Minister established a working group to review all of the laws and policies related to Indigenous peoples, headed by then Attorney General Jody Wilson-Raybould. After 5 months of work, the group, which was comprised entirely of sitting government personnel, released 10 principles on respecting the Government of Canada's relationship with Indigenous peoples. These 10 principles are said to articulate the broad contours of what implementation should look like in Canada. Then strange things started to happen. In August 2017, the Prime Minister announced that the INAC Ministry, the Indigenous Affairs Ministry, would be split into two. One ministry assigned to service delivery, to be headed by former Health Minister Jane Philpott, and the other ministry, called Crown Indigenous Relations, would be led by Minister Bennett. In 2018, working groups set about attempting to produce a federal Indigenous rights recognition framework that would replace the Indian Act. Jane Philpott was on the same day reassigned as president of the Treasury Board. So now we have two ministers who are really unknown entities in these positions. Carolyn Bennett, however, remains the Minister of Crown Indigenous Relations and Northern Affairs. Bill C-262 passed the House of Commons last year and currently is sitting in the Senate, waiting for action. We have had introduced some important legislation on Indigenous languages. Bill C-91 that has come into, that was tabled in January. And another important piece of legislation, Indigenous child welfare legislation, was due to be tabled actually this week or next week, but that has currently been stalled now with some complaints from First Nations that they haven't had proper consultation and input. And other than the 10 principles, we have so far seen absolutely no significant progress on implementation on the federal level since 2015. So Canada, on the federal level, is standing at a crossroads. So on the one hand, this Liberal Party and Justin Trudeau stated their intention to respond to the TRC calls to action, and they set out on a new course to establish a renewed relationship. But on the other hand, wide and sweeping and complex changes apparently are very hard. And this government, which had very high rhetoric, has yet to develop any national action plan in order to make the changes. So the UN Declaration, which has such potential to be a global change maker, so far has seen very little action in any of these important areas. So to conclude, what can we do now that we are facing an election year and very little progress to date? Where can we go from here? Some practical pathways. How an organization, which is not actually an Indigenous organization, could still support and advocate for these positions, either through resolution or through actual lobbying of government entities. Most of all, what's looked for here are coordinated and collaborative approaches to problem solving. So whether this is designing national action plans or actual projects on the ground, the overriding principle is coordinating and collaborating with Indigenous peoples and with First Nations. I would hope that organizations like yours could support the call for a national action plan, and a national action plan not developed just by government people, but in collaboration with multiple stakeholders on the ground, with civil society, with union organizations, with industry, and come to a reasonable national action plan to implement the declaration. Pushing for a full law and policy review on the federal level is essential as a part of that national action plan. And this is one concrete step that was to have been started, but again, with all of the ministry shuffling, has not taken off. There's a need for both political and technical cooperation between First Nations and Indigenous organizations, government entities, provincial level and federal level, again, along with civil society and industry. Legislative frameworks are key. Bill C-262 on the federal level, and then there is a companion bill here in British Columbia that will do similar things on the provincial level, are key, again, to set up a framework and an obligation to have a national action plan, to have annual reporting, and to do the full policy reviews. In and of itself, the legislation does not implement the declaration, but it does provide a framework and an obligation and a pathway to it. And then finally, to look at self-determination and free, prior, and informed consent as related processes, and that they are now the basis of decision-making in this country and in this province. And it's important for everyone to understand that free, prior, and informed consent does not necessarily mean a no to extractive industry or a no to development projects. It simply means that Indigenous peoples who will be impacted by them should be part of the decision-making. And so when it's looked at that way, it's not really so threatening as some of the fear-mongers would have us believe out in the media and out in society. It is just simply a new way of doing business that traces back to the 1970s, to the grassroots of the movement, but is to be the way of the future and the framework of the future. So with that, I'm going to stop with my formal presentation and shift to hopefully some questions and discussions from all of you. So thank you so much for listening. And why are they shifting? I think there were a couple things that went wrong. I think when they initially put all of this on the table with the very high promises and the high rhetoric, they didn't fully understand what they were doing. At least most of them. I think certain people like Jody Wilson-Raybould had studied this issue for decades and had come up with some of the principles of the framework, the legislative framework, many decades ago and had been working constantly on it. But I think some of the top decision makers didn't really know what they were getting into. They saw it as a human rights document that the Harper government had opposed, and therefore they were going to support it. So I think they thought it was a quick and easy political calculation. Then when they got into it and found out that it meant a whole new set of policies and laws and procedures, they realized what a complex box they had opened up. And there have been many attempts over the past few decades to replace the Indian Act with something. The trouble is, no one knows what to replace it with. And creating a vacuum is not something that anyone wants. And so to create that consensus in a very short period of time to put a new set of legislation in just turned out to be a lot more complex and nuanced than anyone had seen coming. Now, I also think that they've come up against some very real political problems in that I think if looked at just from the surface, or from, if we go back to 2014, 2015, one would think that there was a bit more consensus among Indigenous peoples about what they want in terms of development and in terms of an economic model. And so I think when viewed after 8 years of Harper, it looked as though there was a single answer. And I think the political answer for Trudeau was to respond to that as he saw it. Once you're in office, you find out it's a lot more difficult and complicated than any of that. And so we have some Indigenous nations who are very strongly in support of extractive industries and others which are strongly opposed. And these are not easily reconcilable when the projects involved cross both of those territories. And so I think in trying to respond to everyone, you please no one.
Thanks, Sheryl, for the presentation. What do you see the province doing now? They've adopted it, and your presentation there was great towards what the federal government is or isn't doing.
Yep.
And how do you see the province moving forward?
I have a lot more hope for the province at the moment. And I actually am, well, of course, number one, they have to stay in power in order to pass any of this. But they are taking a similar pathway in terms of provincial legislation to adopt and implement that will look, and it is actually patterned after 262. So it will create the same framework in this province. Now, why that matters is not just because it's a heavy extractive industry area, which then sets a tone for the rest of the country. It also matters because in British Columbia, the unsettled nature of the land and land title underneath and the uncertainty here. Because of the lack of treaties, other than a quick corner in the Northeast, which is part of Treaty 8, and a couple treaties on the islands, British Columbia has no treaties with Indigenous people whatsoever, which leaves open the rights and title question in BC. this legislation would then create, in some sense, the most difficult case in all of Canada for implementing the declaration. So if it can be done here, then the rest of the country actually is a bit easier, because the underlying rights and title questions are not quite, as we would say, quite so politically forward or quite so controversial. It would also start to create a process for what free, prior, and informed consent should look like and can look like. And I think the ripple effects of that, if it can be done here, again, create a tremendous positive model for others to look at, not just across Canada, but in the rest of the world.
So I think the question in the Wet'suwet'en Territory currently is part of that discussion, and can it really only be defended through legislative frameworks, political frameworks, when force is being used?
Yeah.
Right?
Yeah.
On behalf of private entities, which
Correct.
aren't beholden to.
And let's step back a little bit to talk about veto, because this is a term that gets thrown about quite often in the media and in op-ed pages. As soon as we start talking about free, prior, and informed consent, it becomes a discussion about veto. What's important to understand is that free, prior, and informed consent does mean the right to say no. It also means the right to say yes, and it means the right to say yes with conditions, because any self-determining person or group has to have that full spectrum, or they're not self-determining. Right. And I always say, if we consider a marriage situation, if a young girl is told by her parents that she's going to marry X person, if she has no right to say yes, no right to say no, or no right to say yes with conditions, she's not actually self-determining. So the right to say no has to be on the table. Now, is it a veto? That's not actually what it means. Veto would be if there was already a separate process of decision making, and then someone is able to come in at the end and veto it and say no. Indigenous peoples do not have that right under free, prior, and informed consent, as does anyone else. What they do have is the right to be involved from the beginning and express dissatisfaction from the beginning. Now, what we're seeing, unfortunately, in northern BC right now is two sets of policy failures where free, prior, and informed consent were involved. One of them is governmental, and the other one is actually internal. Because what's gone on there, unfortunately, is not only that on the governmental side, was there a whole set of people that were not consulted or not brought into the discussions, which is the traditional hereditary leaders, but also on the internal side, the elected band council didn't exercise free, prior, and informed consent and include the hereditary leadership, at least from outside observations. And so it appears that we have a double policy failure, and now we have conflict on the ground. From what I understand in that particular case, and that particular case is good because it shows us how it can go wrong in many ways. We have a case where we need much better tools and principles to get at free, prior, and informed consent. So how do we make sure, so that we don't get into these conflict situations, that those stakeholders are all included from the earliest stages in the discussion, so that the opportunity, if the answer is a hard no, that gets in very early and reduces the conflict rather than coming at the very end. Because that's when we have hard rights problems and explosions like we see. So we need to learn how to do this better and more completely from beginning through all the way to the end. That's my long answer to your short question.
Have there been any countries that, for instance, Canada could use some of the commitments or some of the compliance that they have done that would help Canada with this, I don't want to say convoluted, but very political, complex problem, yes.
Unfortunately, or fortunately, depending on how you look at it, Canada is on the cutting edge.
Uh-oh.
We are, in this country, defining what it means, what it all means. We have some successes and we have a whole host of failures, and certainly the world is watching. We can look at other countries for pieces, parts. So New Zealand is doing some things very, very well in terms of engagement with the state, as is Norway. In Norway, they have, well, also in Sweden and Finland, but Norway is particularly strong, a Sami parliament. So there's an elected body of Sami representing Sami interests. Now, it's only a consultative body to the full parliament, but it exists. And I think it's one piece that we can look at. It's not a perfect implementation model, but it's reasonably good. And I think that if we go back to the Royal Commission in the 1990s, there was a proposal for something similar here in Canada that just never got off the ground. Then in New Zealand, there's also quite a number of practices where Maori have to be involved in a certain level in direct policy approaches. So there's kind of a free, prior, and informed consent model in governance going on in New Zealand. Australia is not one we really want to look to, as is the United States for most cases, although I will say in the United States they are quite advanced with tribal sovereignty in terms of recognizing jurisdiction. So tribes down south have tribal court systems, tribal welfare systems for children that are very strongly bounded to self-determination and sovereignty. So those are things that we could look at because we haven't quite gotten there here, and child welfare legislation is one of those pieces that we would like to see some movement on, and they've had that law down in the United States for about 3 decades now, and the world didn't end, and everything proceeds accordingly, and we've had tribal courts for decades down there. Again, the world didn't end, everything proceeds accordingly. So I think those are some places that we can look, but there is no particular country that's more advanced than Canada right now. So again, that's a good news, bad news story. But in the case of when I mentioned Denmark and Greenland, they are particularly strong, but it's an easy case because Greenland is separate from Denmark and it operates as an autonomous case. So for us in Canada, that's not really such a relevant model. But we can, again, take little pieces, parts, and look at others. And even countries, strangely enough, like Cameroon, have already a national action plan. And so we can look to them at least for some movement on that and say, well, if Cameroon can do it, why can't Canada?
Is there any other questions for Sheryl? Anybody else?
Yeah, wouldn't the first step really be to remove the imposed tribal council system?
Ooh, that's part of the Indian Act. And that's why it has been so tricky, because, again, if you remove that, what replaces it? And so the idea with the rights framework was to develop something that could replace it as it's removed. I think there's quite a bit of danger in just removing it writ large.
But there must have been something in place that for thousands of years.
Oh, absolutely. Absolutely. And that's what we're seeing up in northern BC right now is the conflict between hereditary leadership and elected band councils and the uneasy relationship between the two. And that is a scenario that plays itself out pretty much across the country. The elected band councils in some cases have more and in some cases have less credibility and authority over Indigenous territories. And of course, being any political institution, you have good leadership and poor leadership. And you can pick and choose all the way across the country in terms of elected band councils. But again, what to replace it with? And probably the answer is some sort of mechanism. And it may actually vary from First Nation to First Nation. So there may be some that choose a more traditional model. There may be some that want to stick with the elected band council or something somewhere in between.
Anybody else?
Art, and another quick thought. I know these models predate UNDRIP, but the land trust models of Nunavut and I think Haida as well, do those provide any, like, at least jurisdictional?
Yeah, those are actually really good models, and again, co-developed, which is the key. So, and Yukon in particular is known globally as progressive and functional models. So these are good models. They're not perfect. They're human institutions. They're compromises, and so no one got everything they wanted. But the rest of the world, and especially in the other English-speaking countries and in Scandinavia, does look to those as good governance models. So I think, again, the co-developed, collaborative decision-making process all the way through is really key to getting a good outcome.
Any other questions? I'd like to thank Sheryl for taking time out of her busy schedule for being here. Thank you very much for addressing our concerns or our questions on UNDRIP and Indigenous people's rights. Thank you very much. I have a gift on behalf of CCU for you and all of us, and would like to say if you want to join us for half an hour or so or for lunch, you're more than welcome. Thank you.
Thank you so much.
Thank you.